So, hello to all, good morning. Let's give continuity to the 10th Colloquium on Fundamental Rights promoted by the Catholic University of Minas Gerais, PUC Minas. It's a great pleasure to be here today and a great honor. My name is Lorena Bastaneto. I am a PhD student in Catholic University, and today I greet and welcome Professor Dr. Martin Borowski from Germany and also Professor Dr. Alexandre Travessoni, which is currently based in Germany, but is a professor of the house. Thank you very much for your presence today here and for allowing us to take part in such an incredible and such an utmost important and significant discussion. Thank you very much. I'd like to introduce a little bit Professor Dr. Borowski before giving you the floor. So Professor Dr. Borowski, which will be the main panelist today, has graduated from the University of Kiel, where he has also taken his PhD with the theme of basic constitutional rights as principles. And also in the University of Kiel, Professor Borowski has presented his habilitation thesis on basic freedom of conscience and freedom of speech, freedom of conscience and freedom of belief in the Grundgesetz. Professor Dr. Borowski has also been a visiting professor in the University of Washington and also in the University of Birmingham in the United Kingdom, and devotes himself and his career to publishing books and researches on constitutional rights, constitutional law, law theory, and law philosophy. So thank you very much, Professor. I'd like to present also Professor Dr. Alexandre Travessoni. Professor Dr. Alexandre Travessoni is a Master of Laws and a Doctor of Laws from the Federal University of Minas Gerais, where he is also a full professor of law theory and law philosophy. He's also a professor from Catholic University of Minas Gerais and is currently based in Germany, where he's devoting himself to researches on law theory, law philosophy, constitutional rights, and constitutional law. So thank you very much, professors, for being with us today. Professor Borowski, please, you have the floor.
Well, thank you very much. Thank you for having me, and thank you for setting everything up for our meeting here this morning, Brazilian time, which is actually afternoon German time here in the Heidelberg winter. The topic today is Drittwirkung, a German word, of constitutional and human rights. Constitutional rights are rights of a private party, individual, private corporation, or any other non-state actor against the state. This characterization is suggested by many provisions in bills of rights, in constitutions or international instruments, which emphasize that the state or other manifestation of public authority is the addressee of constitutional rights, rather than fellow private parties. This is to say that private parties are holders of the constitutional right rather than its addressee, so that a private party cannot base a claim against another private party on constitutional rights. At least this is the problem, not directly. There has been, however, a protracted debate as to whether constitutional rights have legal effects in the relation between and among private parties. Since the typical effects of constitutional rights occur between the state and a private party, the question as to whether there are legal effects for another private party, a third party, such legal effects at the horizontal level are called Drittwirkung in German, in literal translation into English, third party effect. This is to say that if one private party is the holder of a certain constitutional right against the state, this constitutional right has Drittwirkung if and when it gives rise to legal effects for other private parties. Since this phenomenon refers to legal effects between and among private parties on the horizontal level, As opposed to the vertical level between the state and a private party, it can also be called horizontal effect or horizontal application. All these expressions are used, they mean basically the same. To understand the reconstruction of Drittwirkung properly, it is well to distinguish three key questions. The first question is, do constitutional rights actually exhibit legal effects between and among private parties? This is the question of the existence of Drittwirkung. The second key question, which has received much attention in the German and European debate, is how to reconstruct Drittwirkung properly. Is direct horizontal effect a more convincing reconstruction than indirect horizontal effect? Finally, if there is Drittwirkung, the question of its strength arises. Do constitutional rights play a key role in shaping the relation between and among private parties, a rather ancillary role? So the question is strong, weak, or something in between. Constitutional rights protect fundamental interests of the individual against interference by the state. The right to life, as a negative right, protects against, for example, being killed by the police. One's fundamental interest in being alive can, however, also be harmed by fellow private parties. I can fall victim to murder in the context of, for example, a robbery. The decisive question is whether the state can remain completely indifferent towards dangers arising to fundamental interests of private parties from other private parties. If the murderer is imprisoned for life by the state, this is in interference with the murderer's right to liberty. This interference is justified because this criminal sanction pursues the end of protecting the members of the public from being murdered. Because if you know you get imprisoned, you will actually refrain from murdering other people. At least we hope so. This is to say that the state is empowered and indeed, as I will argue later, under a constitutional obligation to protect the life of its citizens against dangers from fellow private parties, at least to a certain extent. This indicates that the state cannot remain completely indifferent with an eye to the horizontal relation between and among private parties if private parties cannot protect themselves with reasonable effort, which clearly points towards at least some measure of Drittwirkung. So the if question, the existence question, is to be answered in the positive. The issue that has dominated the German debate, whether there is direct Drittwirkung, which means that constitutional rights establish legal obligations directly between and among private parties, or indirect Drittwirkung, which is to say that constitutional rights influence the relations between and among private parties indirectly. Let's begin with direct Drittwirkung. Hans Karl Nipperdey, president of the German Federal Labor Court in the 1950s and 1960s, defended the idea of direct Drittwirkung in academic commentary first, and it became later the reconstruction preferred by the German Federal Labor Court for no less than 3 decades, basically because he was the boss. Two forms of direct horizontal effect can be distinguished. According to the first form, another private party simply takes the place of the state in the vertical relationship between private parties and the state. It is easy to see that this can hardly work, for the provisions recording constitutional rights are tailored to the state and its specific powers. For example, the state is empowered to limit constitutional rights by the decision of the democratically, directly legitimated parliament, and there is no meaningful counterpart of this for private parties. What is more, the state is under a stronger obligation to consider an individual's need for protection than other autonomous human beings. The state must always act in a proportionate fashion towards its citizens. But do other citizens have to act in a proportionate manner towards all other citizens on all occasions? It's actually meant as a rhetoric question, and the supposed answer is no, I would think. This simplified form of direct horizontal effect has received little, if any, support in the literature. According to the second, more reasonable form of direct Drittwirkung, an individual's obligation stemming from constitutional rights is modified with an eye to scope and strength compared to the obligation of the state. I shall, as a brief remark, say that as far as Germany is concerned, this goes against the clear wording of the provisions according to which only the state is the addressee of constitutional rights. Okay, but an argument that has repeatedly been made on behalf of direct Drittwirkung is that some private parties can be as powerful vis-à-vis other private parties than the state typically is. For example, large employers or large economically powerful landlords. This, however, begs the question where the threshold of power of a private party is located, which needs to be crossed so that a private party is equated with the state. How powerful do you have to be in the state's position with an eye to constitutional rights? Does that mean, if one follows this idea, does this mean that there is direct horizontal effect against powerful private parties, but not direct horizontal effect against private parties that are not powerful? That would be a mixed model. I don't think someone has actually suggested this thus far. It occurred to me in preparing our meeting here today, actually. We might want to explore that. I don't know. It's a new idea. It's not my position, by the way, of course. What is more, the idea that a private party resorts to vigilant justice for enforcing alleged constitutional obligations of another private party amounts to either anarchy or civil war. Enforcement, of course, had to be entrusted to the state anyway, so that there would be an indirect enforcement of direct Drittwirkung. Strange idea, I think. This is to say that direct Drittwirkung is hardly a convincing reconstruction in states, at least in states in which the text of the Constitution declares the state to be the addressee of constitutional rights. And this applies the more, I tend to think, if a more promising reconstruction is available. And that is, you guess it, indirect Drittwirkung. Günter Dürich, an influential constitutional lawyer during the first decades under the Basic Law, German Basic Law, argued on behalf of indirect Drittwirkung in the classic form. The provisions recording constitutional rights also establish an objective order of values, objektive Wertordnung, which give rise to a radiation effect, Ausstrahlungswirkung is the German term, on law below the Constitution, an effect that influences every legal relation in the legal system. According to this reconstruction of indirect horizontal effect in the classic form, any legal effect between and among private parties is established by means of private law or other subconstitutional law applicable at the horizontal level. Constitutional rights do not establish rights and obligations between and among private parties, but they influence the content of private law or other subconstitutional law in the horizontal relation. And it was basically Dürich's version of indirect Drittwirkung that the German Federal Constitutional Court, GFCC, German Federal Constitutional Court, supported in the seminal Lüth decision in 1958. Erich Lüth, a politician from Hamburg, called to boycott of the then latest film of director Veit Harlan, who had earlier, under the Nazi regime, produced the notorious anti-Semitic film Jud Süß at the behest of Joseph Goebbels in 1940. Harlan was awarded damages in the post-war German democracy, was awarded damages because of intentional damage contra bonus mores, according to section 826 of the German Civil Code, by the Higher Regional Court Hamburg. Lüth's constitutional complaint, he filed a complaint against this judgment. Lüth's constitutional complaint brought the case before the German Federal Constitutional Court, which ruled that Lüth's call to boycott was justified by freedom of expression as a constitutional right, so that the expression intentional damage contra bonus mores, general clause, open to evaluation, in section 826 needs to be interpreted in conformity with the Constitution, to the effect that in Lüth's case does not count as an instance that gives rise to damages. Since constitutional rights also established an objective order of values, objektive Wertordnung, any judge who is called to decide a lawsuit between and among private parties is not limited to apply private law as such. He or she is also empowered and required to interpret private law against the backdrop of the objective order of constitutional values. The obligations between and among private parties in such cases remain private law obligations, the content of which, however, is determined also in conformity with the Constitution. The issue of Drittwirkung was again at stake 11 years later in another decision, Blinkfür. The local magazine Blinkfür in West Germany. Blinkfür basically means lighthouse. It's actually a lighthouse at the coast that directs the ships, and this is a metaphor, obviously. Yeah, okay. Blinkfür in West Germany continued to print the television programs of the socialist German Democratic Republic, the so-called German Democratic Republic. Well, it was German, but it wasn't democratic, and it wasn't a republic actually too. Socialist regime, even after the East German regime erected the Berlin Wall in 1961, and this was the political controversy. The conservative West German publishing house Springer threatened news agents that they would not continue to supply their papers to those news agents who also sell Blinkfür. If you sell Blinkfür, you don't get our products. Full stop. This was a serious economic threat, since news agents generally dependent on the turnover and profit generated by Springer's popular high circulation papers. Most gave in to the pressure. Blinkfür sued Springer for damages and finally lost before the German Bundesgerichtshof, the highest court in Germany for civil law matters, because the court regarded Springer's cause of action as protected by their constitutional freedom of expression. So they thought they had just learned this in Lüth, but actually, to their surprise, the case turned out differently. The German Federal Constitutional Court disagreed because a mere economic threat does not, they said, count as a permissible means in a debate in a deliberative democracy. In a democracy where the argument counts because it's the better argument, not because you have economic power. Deliberative democracy, such as Germany. Germany is a deliberative democracy. At least this is the idea. Well, the reality, we try to bring it as closely as possible to the idea, but this is ideal. This is always, as we know, difficult. Although criticism in the literature never fell completely silent, and the idea of direct Drittwirkung was, for example, preferred by the European Court of Justice in Luxembourg for many of the union's market freedoms. This is, so to speak, another round of the direct-indirect problem. The German Federal Constitutional Court confirmed this case law, Lüth and Blinkfür, this case law in a great many subsequent decisions, dozens of decisions actually. And the idea of direct Drittwirkung as the rule proved to be a model that was adopted by, let's just say, many constitutional systems over the last 5 or so decades. To arrive at a comprehensive reconstruction of indirect Drittwirkung, indirect Drittwirkung in its classic form needs to be developed further into what I shall call Drittwirkung mediated by rights against the state. The idea is that Drittwirkung is always mediated by rights of one of the private parties against the state, either a negative constitutional right or a positive constitutional right. And indirect horizontal effect then is established by the content of the rights in the vertical relationship, because the content in the vertical relationship refers to what is permissible in the horizontal relationship. So to speak, the horizontal element is encapsulated in rights at the vertical relationship. This is the basic idea. Well, the outcome is more or less the same compared to the classic form, but it's actually a more thorough and more convincing reconstruction, I shall think. Now, for this, it is crucial to distinguish two sides of such horizontal effect: the side of Drittwirkung by means of negative rights and the side of Drittwirkung by means of positive rights. The Lüth case illustrates Drittwirkung by means of negative rights. Lüth was required by a German civil court to pay damages to Haaland because of the allegedly unlawful call to boycott. This, the court, the judgment, is an interference with Lüth's negative right, namely freedom of expression, hence negative side of Drittwirkung. The court is a state organ whose actions are legally attributed to the state, independent of whether the state interferes for the sake of the protection of other individuals, private individuals, or not, just for the general public good. This interference by the court is only justified if and when this interference has a basis in a parliamentary act, in the Lüth case, section 826 of the German Civil Code, and second, represents an interpretation of this act that is in itself constitutional. The interference in the Lüth case was not constitutional since it was disproportionate with an eye to Lüth's freedom of expression. Drittwirkung also has another side. For example, in the Blinkfür case, there was no interference with Blinkfür's liberty by state action. The economic pressure applied by Springer on the news agents was the act of a private party. And this act of a private party cannot simply be attributed to the state. Rather, the problem was that the court refused to grant protection to the small magazine against the economically powerful media corporation, Springer, which ruthlessly tried to enforce its political opinion by means of sheer economic power. This is to say that the problem was not unconstitutional action. It was unconstitutional omission. For the second side of Drittwirkung, rights to protection are key. Rights to protection against the state are instances of positive constitutional rights in the liberal tradition. Their content has nothing to do with positive rights in the economic sense, social rights. So it's positive right, but it has a liberal foundation. Such constitutional rights to protection in the liberal tradition have been generally accepted in German constitutional law for more than 4 decades. They are now simply understood in constitutional theory. Blinkfür sought the help of the state to defend itself against the unfair boycott. The state, however, declined to protect Blinkfür against Springer. The German Federal Constitutional Court declared, however, that Springer's cause of action was not definitively undergirded by the constitutional right to freedom of expression, which then tipped the balance in favor of Blinkfür. Thus, under the circumstances of the case, Blinkfür had a definitive right to protection against the state to have its freedom of press protected. And the only means available for such protection was to sentence Springer to pay damages to Blinkfür. A proper reconstruction of Drittwirkung, as I think has become clear by looking at Lüth and Blinkfür, presupposes both sides. Both Drittwirkung by means of negative rights and Drittwirkung by means of positive rights. It simply depends on the facts of the case as to whether the state interfered excessively with one private party's liberty or refused to grant the constitutionally required minimum of protection to another party. In the former case, Drittwirkung by negative rights is key. In the latter, Drittwirkung by means of positive rights. So we need both sides. There are attempts to say the negative side is enough, attempts to say the positive side is enough. I think this is both wrong. We need both sides. There are 2 kinds of cases, and we need the two sides for these 2 kinds of cases. Now, a rare category, but systematically, I think, an important category, rights to legislation. Thus far, Drittwirkung mediated by rights against the state has proven to be a reconstruction of indirect Drittwirkung in the classic form. So we understand it better, but not really changes much. However, any such indirect horizontal effect in the classic form depends on the existence of an act of parliament. An act of parliament that can be interpreted in conformity with constitutional rights. And we run into problems when we don't have such an act of parliament. There is none. We run into problems if there is no act of parliament to be interpreted in conformity with the constitution, or we run into problems if there is an act of parliament, but our legal methodology, our theory of legal argumentation, does not permit to an interpretation what would be the constitutionally required interpretation of this act. Under such circumstances, rights to legislation come into play, which is to say that also the legislator can be the addressee of Drittwirkung brought about by constitutional rights. Cases are rare, but there is a German case. It is a case decided in 1990 by a Hessian. Hessen is actually a state. Germany is a federal state, is a state in Germany, north of Baden-Württemberg, in which Heidelberg is located, Hessen. And the higher administrative court there ruled in 1990 in a case in which a license to operate an industrial plant for the protection of insulin, treating diabetes. And this plant made use of genetic engineering. Now, genetic engineering was new at the time, and people thought it would be terribly dangerous to undertake such genetic engineering. And also at the time, there was no act of parliament in Germany for the regulation of the industrial use of genetic engineering. So there was no statute, no parliamentary statute, that could be interpreted with what was in the view of the court, the constitutional requirement of protection for life and health against the dangers arising from genetic engineering. The problem now is this. If the executive wanted to prevent the company from engaging in the use of genetic engineering, this prohibition counts as an interference with the company's freedom to pursue one's business as one wishes, Berufsfreiheit, according to Article 12, paragraph 1 of the German Basic Law. Such a prohibition has to be required by law, which is to say that there has to be an act of parliament that provides for such prohibition, or at least empowers the executive expressly to declare such prohibition. There was, however, simply no such act of parliament. Strictly speaking, the executive could not do anything. And now this Hessian court made a bold move. It regarded genetic engineering to be so dangerous that industrial use of genetic engineering would be permitted only after express permission in a parliamentary statute. And this, unfortunately, is nothing less than the reversal of the fundamental principle that liberty is the rule and the limitation of liberty the exception. And it doesn't come as a surprise that this decision met with fierce criticism in academic writing. If one actually regards genetic engineering to be quite dangerous, and if an interference with liberty of the pharmaceutical company requires that there be an act of parliament, this is now the right solution to this problem, only a constitutional right to legislation offers a sound solution. So if we need to limit someone's liberty, and if this limitation of someone else's liberty requires a parliamentary statute for granting protection, so there has to be an act of parliament. So the Constitution requires there to be one. This is a definitive positive right to legislation. This is to say that there might be, at least under exceptional circumstances, these are rare categories, but there may be a definitive constitutional right of members of the population, of the public, to have the company's freedom to pursue one's business as one wishes limited in this or that respect. Finally, with an eye to the strength of Drittwirkung, it is worth emphasizing that the second and the third question are often intermixed on the basis of the assumption that direct Drittwirkung is necessarily strong, or tends to be strong, while indirect Drittwirkung is necessarily weak, or tends to be weak. This is not, however, true. There can be weak Drittwirkung as well, weak direct Drittwirkung as well as strong indirect Drittwirkung. It's both possible. The strength of the horizontal effect is largely a matter of normative argumentation. It depends on the substance of the aspects involved, and this is not necessarily decided by the analytical issue of how to reconstruct the Drittwirkung as direct or indirect. Now, one question, of course, remains. Considering what are, in my view, the clear arguments on behalf of indirect Drittwirkung, Drittwirkung mediated by rights against the state, why do so many people fancy with the idea of an erga omnes effect or of direct Drittwirkung of constitutional rights? In short, human rights as moral rights are actually rights erga omnes. But this erga omnes character of moral rights is typically lost if and when moral rights are transformed into law. Once they have been transformed into constitutional rights, human rights, these constitutional rights exhibit indirect Drittwirkung, not direct Drittwirkung. Now, this needs some explanation, I think. Human rights in the sense of moral rights are morally valid if and when they are morally justified. It's just a matter of correctness whether they exist or do not exist. Authoritative issuance, for example, having been recorded in a constitution or an international treaty, and or social efficacy, being obeyed by the population or sanctioning non-obedience by the population by the state. Authoritative issuance and social efficacy are no requirements of the validity of a human right as a moral right. Moral rights as human rights do not even presuppose the state. They are addressed erga omnes. For example, assuming that person A got lost in the desert and does not have enough water to get back to safety. Now he accidentally, fortunately, meets person B, who has enough water for himself and, fortunately, enough water to save A's life too. So no conflict. These are the tricky cases. This is the simple case, actually. A has no water, B has enough water for both of them. Fantastic. Lucky day. In such a case, the human right to life as a moral right suggests that person A, has a definitive moral right against person B to be given the amount of water that is necessary to survive. The moral right to life has, I would argue, direct Drittwirkung or direct horizontal effect. Well, the problem may be this is not Drittwirkung because there's no state, actually. So, okay, but for the sake of my parallel scenario, just go along with me on that front, please. Okay, now the problem of moral rights is that moral rights do not lend themselves to effective enforcement. If person B refuses to give person A water, B doesn't like A, actually, for whatever reason, and person A then consequently dies from thirst. We know that person B definitively acted immorally. Okay. The problem is, however, B will not face any sanction whatsoever. Nothing will happen to B unless he has bad conscience or something like that. But this is, of course, something we don't know. Human rights, as moral rights, human rights morally demand that certain fundamental interests, life, free speech, religion, and so on, are effectively protected. Since moral rights themselves cannot provide, by their nature, for effective protection, they demand that they themselves be transformed into legal rights. Legal rights presuppose a legal system. Unlike morality, law has a strong, real or factual dimension. Legal norms are only valid if the norm was authoritatively issued and is socially effective. The most important aspect of the authoritative nature of law is, however, that legal norms lend themselves to effective enforcement. And this is why the moral content of the human right needs the legal form of a constitutional right. A second reason for the transformation of human rights as moral rights into the law is that it is often unclear and contested what human rights as moral rights require. There are different catalogs of human rights that have been suggested by different theories in political philosophy. And even if one agrees in principle on a certain catalog of human rights, there will be often disagreement on how to resolve cases in which different human rights of different people actually are competing under certain circumstances. For the sake of clarity and certainty of cognition, there needs to be an authority, the Constituent Assembly, that decides which rights count as constitutional rights, and there need to be further authorities who decide on the concretization of constitutional rights under the circumstances of the respective case at hand. Authoritative concretization by means of legislation, parliament, and by means of courts balancing competing constitutional rights in the legal system. Once the transformation of a human right into a constitutional right has been undertaken, authoritative cognition and effective enforcement have been ensured. The price of the transformation is, however, if one follows me on that count, that the erga omnes effect of human rights as moral rights has changed into an effect mediated by the state. Coming back to the desert example, person A has a constitutional right to protection against the state to the effect that the state makes sure that people in the situation of person B hand over enough water so that person A can survive. The state will typically do this by enacting a criminal statute that will make the failure to assist a person in danger, this would be a kind of legal phrase, failure to assist a person in danger, a punishable crime, such as section 323C of the German Criminal Code actually requires. The transformation just described of the moral right into the legal constitutional right does, of course, not consume the moral right. It is not gone after transformation. Even after transformation, the moral right continues to exist and undergirds the constitutional, the legal right morally. The indirect Drittwirkung of constitutional rights then proves to be a continuation of the moral rights erga omnes effect beyond the process of transformation, albeit then in another form, in the form of indirect Drittwirkung, which is more appropriate for law. In this sense, constitutional rights without Drittwirkung or with too little Drittwirkung would not count as a proper transformation of human rights into the law. To conclude, the erga omnes effect of human rights as moral rights undergirds indirect Drittwirkung of constitutional rights. Thank you for your kind attention. Thank you.
Yes. Okay. Thank you. Thank you very much, Professor. Am I audible now? Thank you very much for your lecture. We are very flattered and honored to be part of this utmost significant discussion. The audience is very flattered as well and honored. And thanking you very much for letting us taking part of this panel of today. So now I will be giving the floor to Professor Dr. Alexandre Travessoni, which will be assuring the adversary mode as a debater of this great discussion. Thank you, Professor. Professor Alexandre, please.
Thank you very much, Lorena. First of all, I would like to thank very much Professor Martin Borowski for this wonderful lecture at our 10th colloquium. This is the 10th time this colloquium takes place. And for me personally, it is an honor to have Professor Borowski not only here at the virtual environment, but also here by my side. So, and I take this opportunity to thank him for this wonderful welcome here in Heidelberg. So I'd like to also thank Lorena Bastianetto for this, for moderating this section, Alexander Marques Silva for helping us with the organization, Professor Julio Aguiar de Oliveira, who is certainly watching us, but because he's shy, maybe he didn't want to be here with us, and also Professor Marciano, the dean or the head of the graduate program from PUC Minas, who sent me a message. He's also watching us. So I thank, and also, of course, thank all the many participants who I know that are here for watching us. And I'm going to make a short comment on Professor Borowski's wonderful lecture, not properly a technical remarks or technical observations on the, so to speak, the dogmatic aspect of the third party effect or Drittwirkung, but something more in the direction of legal theoretical approach regarding the concept of addressee itself, of legal duty, and so on. We had an interesting discussion yesterday about that. Professor Borowski already told me that he doesn't find my ideas crazy. But anyway, there are a few things that I did not say yesterday. I had to keep something in my pocket. So anyway, first of all, a general comment. Thank you very much for the well-structured lecture. I fully agree with the distinction between or among the aspects which you present in your paper: existence, reconstruction, and strength. That seems very much helpful, and I had never thought about that before. Of course, you mentioned that, but of course, one can only talk about reconstructing third-party effects if they exist. Right? So it's an important question. I agree with you that if there are two possibilities, direct and indirect Drittwirkung, indirect Drittwirkung is the best choice. It seems to me, especially in the first version which was presented, saying that the citizen or a company, no matter how powerful it is, will somehow replace the state. It doesn't make sense, because these seem to me, these legal phenomena, they seem very, very different to me. So I fully agree with you that if we have as an option either third-party effect or not, and if we have as the only option to defend that there is a third-party effect, then we have to choose, of course, and I think that this has been proven by you in your lecture. We have to choose indirect Drittwirkung. My question, as you know, we discussed a little bit yesterday, is whether we could say that there is no Drittwirkung, because fundamental rights or constitutional rights are rights whose addressees are not only the state, but whoever has a duty. And then, yes, of course, I understand the argument, and I understand that so to say, the theory which we are debating now is a typical German theory, and as you stressed, a theory that was created within the context of the German Constitution, which expressly states, I have it here somewhere, in Article 1, Paragraph 3, that the following, please correct me if my translation is not good, the following constitutional rights binding legislature, the executive power, jurisdiction, they are binding as immediately valid law. I don't know whether my translation was good, but anyway, the German constitution states expressly that these rights, they bind the state powers. So it makes much sense to create a theory in which the addressees or the addressee is the state. But then my question would be, and that would be my first question, whether this is a universal definition or concept of constitutional rights, or and consequently from third-party effects, or whether such definition is valid only for countries, like you mentioned in your lecture, in which the Constitution states that the constitutional right is directed primarily towards the state. As far as I know, the Brazilian Constitution, I checked yesterday, does not mention that fundamental rights or constitutional rights are directed only, not only the Constitution, the Brazilian Constitution does not mention that constitutional rights are directed only, it doesn't mention who the addressees are in the case of Brazil. And in the case of Brazil, we don't even have something like Article 1, paragraph 3 of the German basic law. So that would be the first question. Is a definition in which the addressee is only the state, and then, of course, if the addressee is only the state, and if the constitutional right somehow binds other people, this has to be called third-party effect, because they are not the addressees. Okay, my suggestion would be that is not a universal definition, but rather a definition which is valid only for countries where it's quite clear and accepted that the addressee is the state. But then I dare to go maybe further and say, and that might be maybe not prudent, but anyway, I would like to say that even in countries like Germany, where it seems that the constitution puts or establishes as the addressee the state, that might not be quite appropriate. And I have very quickly, I would like to draw a few arguments. Our first argument: the idea, if I understood correctly, is that fundamental rights are typical rights against the state. It seems to me that Article 1, paragraph 3 is not enough to say, it's possible to say that the addressee is the state, but it's also possible to say that it is one of the addressees. And my idea would be to suggest that even in countries like Germany, constitutional rights are rights addressed to all of those who can violate the right. Okay. So this idea of typical, we would then have to discuss from the point of view of legal theory what a right is. In order to discuss that, I believe we would have to discuss what a duty is. As we all know, and I know that Professor Borowski knows more than I do, that for Kelsen, for instance, a right is a counterpart of a duty. So if the Constitution establishes duties, the right is defined according to these duties. If the Constitution establishes duties that the state and private parties have to obey, I would say that not only the state, but rather all of them are addressees. The third argument was already faced by Professor Borowski, but I just want to repeat it very, very quickly, is the human rights argument. it seems to me that the idea that if constitutional rights are positive human rights, and if one argues that during the process of positivation, they lose their erga omnes character, this needs a legal theoretical justification, in my view. Of course, one can say, one can find such justification, but my idea would be that, as a Kelsenian, I would say that it seems to me, Professor Borowski, that would be a second question. I would suggest, I know that's daring, that even the Constitution establishes duties to the state indirectly from a Kelsenian point of view. So even the duty the state has to protect the citizen, what in Germany is called the constitutional right, is somehow indirectly created. It doesn't create, the Constitution normally doesn't have a sanction. What in Brazil we call infra-constitutional legislature, what in German one calls Einfachheitsrecht. I don't know, how would you say that in English, but anyway, common legislation. Yeah. Anyway, so that would be my another argument. And then my last observation, I'm already taking too long, would be social rights, especially in a constitution like Germany's constitution. As I think most of our viewers know, the German constitution does not have explicit dispositions creating or so to say establishing social rights. It's usually in Germany the term zugeordnete Rechte. So if I'm not mistaken, Julian Rivers, the translator of the theory of constitutional rights, translated that, I have noted here, interpretatively derivated constitutional rights. So it means rights that are not expressly established by the Constitution. So it seems to me that in Germany, and that's not the case in Brazil, constitutional social rights are indirectly created by the Constitution. I understand one could say, okay, that doesn't have anything to do with third-party effect, Drittwirkung. The indirect character here has to do with something very differently. But I would argue that in the end, it does. Because if a right is interpretatively derivated from the Constitution, there is no sanction on the Constitution. We need legislation under the Constitution in order this right is so to say, established. So, of course, the things are not the same, but there would be a connection. And the last observation, this is really the last one. It's very interesting in my view that in Germany, and that I learned from your lecture, and I thank you very much for that, that the idea of the Drittwirkung appeared for the first time in labor law, right? Because it seems to be an area of the law in which, of course, one could say, if the right is addressed to the state then has a duty to watch whether a company is paying a person the right salary. But the idea that the duty is also addressed to the third party seems to me more intuitively clear in labor law. So that's very interesting. So I thank you very much again to my host, and I have the pleasure to say not only a colleague, but also a great friend, and thank him again for providing to us this wonderful lecture this morning in Brazil, this afternoon in Heidelberg. And thank you very much, all of you, for being here with us. And
thank you. Thank you very much, Professor, for your questions and for your discussion, for opening this great discussion. I would like just, before giving the floor to Professor Dr. Martin Borowski, just to incentivize our audience today to ask questions here through chat, and we will be addressing. You can ask questions in Portuguese or in English, or auch auf Deutsch fragen. Okay, so thank you very much. So Professor Dr. Martin Borowski, you have the floor.
Yeah, thank you. I shall be brief in addressing the remarks and questions of my friend and colleague, actually sitting to my side. To begin with, he praised the clarity of existence, the distinction between existence, reconstruction, and strength of Drittwirkung. And I'm afraid I have to pass the compliment on, because this clear distinction is something I learned from Robert Alexei. I'm one of his disciples, and I benefited very much from him in the clarity of thought, but indirectly, but in this sense, actually very directly, because he places, in discussing Drittwirkung himself, he places these distinctions center stage. Yes, I hope that this was expressed at least in subtle form in different passages in my presentation. There are, of course, two questions we have to address. The first question is, how do we deal with the problem of Drittwirkung in German constitutional law? And we have a constitutional text, and Alessandro has referred to the text. I will come to that in a second. And of course, we have then the more general problem of models of how Drittwirkung, horizontal effect, can be reconstructed generally. And of course, it is understood. This is, I hope you do not get the impression that this is some kind of neo-colonial attempt to export like Audi's, Mercedes, and BMWs export some kinds of constitutional ideas and ask other people to just follow. It is, of course, the constitutions, the text of the constitution, and not only the explicit text, but also the implicit assumptions and implicit processes and legal practices in constitutional orders can, of course, then make a difference. And if you remember that I at least briefly mentioned that I do not think that indirect Drittwirkung is necessarily weak and direct Drittwirkung is necessarily strong, so that we should have the debate with an eye to the reconstruction based, be it explicitly or implicitly in a hidden way, with an eye to what is the outcome I would prefer, strong or weak Drittwirkung. I think this is something you can just uncouple, and I think you should uncouple. Now, Alessandro referred to, so this is the universality question. There is a universal question, and there are answers we have to give to some extent to the universal question, but then the universal question changes somewhat if we look at the problem from the perspective of a specific constitutional order. And here text and implicit assumptions can make a difference. So this is the answer to the question, is this a universal definition? Well, yes and no. There's the universal problem, and we have to solve it, and there is a local or parochial problem, and we have to address that as it is. One thing, maybe from a comparative perspective, in some sense, the idea of indirect Drittwirkung, particularly if you look at it from the perspective, I think, where it is more thoroughly and more consequently reconstructed, the modern form, not the classic form. This makes clear that you need, for a fully developed idea of Drittwirkung, you need constitutional rights as negative rights, and you need constitutional rights as positive rights. Now, constitutional rights as positive rights of course, require what I would call a strong state. Not necessarily a socialist state, a state with much redistribution of wealth. This is, of course, another discussion and one kind of different points of view on that. But it requires a strong state in the sense that if someone has to defend his or her fundamental interests against fellow private citizens, that you have a strong state that if you call for help, the state will be there and answer and enforce. Now, this is something that some people, I think, very much north on the upper part of the American bicontinent would, of course, answer differently. They would probably say something in a very simplified form, well, give them all guns and let them fight it out. So there is not a strong state, and people looking for protection of the interests just resort to their own strength, to weapons and some kind of private things, rather than actually look to the state. So this indirect model, in some sense, is necessarily based on a state that effectively enforces, accepts, and then enforces rights to protection. And if your tradition, your constitutional culture, your political system is just, so to speak, completely different on that count, it would probably be difficult without any adjustments to just take this model over. So this is actually a caveat. And this brings us to the issue of what you call in comparative law legal transplants. Although I do not think that our North American transatlantic brothers and sisters are very keen on the very idea to take, so to speak, a central point of German constitutional theory to their political system. I think this is an anathema to them. Okay, be that as it may. The second point is actually interesting because it's in some sense a conceptual point. It surfaced when I was talking about, in the desert example, whether there can be Drittwirkung of moral rights. Well, there are no free parties, there are only the two private parties. In some sense, I have to admit, this is constitutionally, the language is distorted, because in the German constitution, indirect Drittwirkung is understood, so to speak, the normal legal solution. This was not really questioned, and those who were proposing direct effect were the rebels. And, so to speak, the orthodox solution, based on the provision that actually Alexandre here translated for us, Article 1, Paragraph 3, which is read. It says the following constitutional rights actually bind, and then all three branches of government are following. Now, this has a positive side, this provision, because it makes clear that the legislator is bound by constitutional rights. That was different under the Weimar Constitution. At least there was a big debate as to whether and to what extent the legislator was actually bound by these constitutional provisions. So this is the positive answer. But it also has, at least this is the orthodox reading, it has a negative side too, in the sense that exclusively the state is technically the addressee. Now, this may be different in other constitutional systems. I think this is, I don't know it so well, because I shall refrain from mentioning the country. But I think there is at least one Latin American country which basically has a provision that resembles the German provision, but then there is also something else in the constitution of this very country that makes at least implicitly clear that private parties are also committed to constitutional rights. So if you have such a constitutional text, then the whole perspective changes. And it may well be that you can argue, okay, well, this is here, combined, these two provisions make clear that there are actually also private parties. It can be, from from a conceptual point of view, be the addressees of constitutional rights. At least I'm more familiar, of course, with the European context, and we are not, of course, talking only about constitutional rights, although I did so mainly here, I know. The same question, of course, arises for every international legal instrument. And if you look at the European Convention of Human Rights, the Article 1 basically says that the high contracting parties, the member states, promise to protect the following liberties and blah, blah, blah. So it's actually, they are the addressees, not other fellow private parties are addressees of the convention rights. Of course, you know much more about the American Convention of Human Rights, but I reckon this is more or less the same. And this also applies to the European Union's Charter of Fundamental Rights of the European Union, which basically has, owing to the specific situation of European Union right, it has in part the Union, public authority, as addressee, and in part the member states. And of course, in both cases, all three branches of government, the legislature, the judiciary, and the executive. So, so to speak, it's a double 1-3 basic law in some sense, but it again is only public authority. It's not private parties. So, yes, it may well be that other countries have a different solution to that, and they can have a different approach, and I think they can go towards direct Drittwirkung. But at least in Europe, it is the, so to speak, standard approach, the normal situation, to refer to indirect Drittwirkung. And then you said, I wrote this actually, all who can violate the rights are addressees. Well, this of course is, I'm afraid, circular, because I would argue, now I don't want to harm you, but if I would be about to hit you, you could say, well, you are violating my fundamental right to bodily integrity, and I would argue, well, I can harm you, I can hit you, but I can't actually violate this right because I'm not an addressee. Because I'm not an addressee, I can't violate it. So I think the idea, capability, obligation, or being an addressee, obligation follows capability of harming someone's interest. This is, so to speak, the basic thrust, I think, of your argument. That goes along some way, but not, I would say, towards direct Drittwirkung. Actually, in some sense, I shouldn't say I feel misunderstood by you. This would be go a bit too far. But in some sense, I think I'm trying to present at least some form of reconciliation between indirect and direct Drittwirkung, in the sense that I say, well, the constitutional rights as legal rights are the result of the transformation process of moral rights into the law. And actually, as moral rights, which continue to be there, they have direct effect. And this direct effect of the moral right is still there and kind of forces constitutional rights at least to have indirect Drittwirkung. And they actually are the positive, they undergird the positive answer to the existence question. And this is, of course, also important. There's not much time, I think, today to talk about this. But of course, then the moral assumptions you presuppose, of course, play an important role for the question of the strength of Drittwirkung, be it direct or indirect. I'm not so, so to speak, decided on the general theory. For the German side, the answer, I think, is rather clear. So you confess to be a Kelsenian. So yeah, I'm a member of a very small and elite group nowadays. I would say. I think we can learn much from Kelsen, but Kelsen went so far to the extremes that it is actually difficult, I think, to be a Kelsenian. Now, with the indirect creation, the key idea is, and I don't know whether your Kelsenian reconstruction actually captured this adequately. You say there are indirect obligations of the state. Yes. Now, the point is, you can have an obligation, but the obligation is so to speak, for the benefit of someone. And this is the key idea when I said that the horizontal relationship, when the Drittwirkung is mediated by rights in the vertical relationship. In the vertical relationship, so to speak, the horizontal duties are encapsulated in the content. Now, it might seem as the horizontal relationship has vanished, but actually it's there. It's only there in the content here in the vertical relationship. And with an eye to social rights, interestingly, I never thought about this. Thank you for this remark. I never thought about this. I think that the idea of social rights actually underscores the necessity, at least in the German context, of the indirect reconstruction. Why? Because think of direct social rights. So people who are poor would ring at my door and collect their money. Because I would be on an obligation, constitutional obligation, to hand over my money. Now, it would then depend on the ratio of the poor and wealthy people. Of course, poor people living close to many wealthy peoples would very easily collect money. And the question is, how do we actually, if someone comes and says, well, there are 300 people here around, I'm entitled to 300 euro, give me €1. Now, okay, €1 is for many people in Germany not much money. But of course, if a queue forms at your front door and the queue is actually 300 meters long, this is what Robert Alexi, in the context of the argument of transforming moral rights into legal rights, it's the third argument. The argument from cognition, the argument from effective enforcement. These were the two arguments I mentioned. And Robert also has the argument from organization, because if it comes to social rights, and if someone is entitled to 300 euros per month, for example, as a poor person for the subsistence level, then running around collecting money, how shall we control? How shall we review? Who has already given how much money to whom, and how do we do this distribution? So there is not really a realistic theory of social rights other than having the state under an obligation to hand out the money to certain people who are in social need, and then taxing the wealthy. So this means the state is at the whole center, and the state organizes the whole thing. So in that sense, there's, as Alexandra correctly pointed out, there are no explicit social rights in the German Constitution, which is a long, sad story, because in the Weimar Constitution there were. Nobody knew what to do with them. It was very ideological. And then when the post-war constitution in Germany was actually recorded, the Constituent Assembly said, well, we are not opposed to social rights, but we basically don't know how to do it. And in the last round in Weimar, it ruined the whole constitutional right topic, because it kind of poisoned the whole thing. And so for the sake of clarity, we want clear liberty rights, we want clear equality rights. We record these in the Constitution. We make sure this is binding law for all branches of government, Article 1.3, he quoted it, and we go with that. And for social rights, well, we shall see. It was not an ideological decision, well, we don't want to have provisions, but it was the kind of benevolent, well, we would like to, but we don't know how to do it. And I'm not so sure whether it would have changed if we were to make a new constitution nowadays, because the structure of social rights is, I think, in terms of structure, still somewhat of a miracle. There are question marks there. So, but the general thrust of my answer, and I shall conclude because I promised to be brief and I already violated that promise. The thrust of my argument is, well, the indirect reconstruction for social rights is actually the only one I could reasonably think of. Yes, and labor law, of course, this is very apparent that some private parties can be powerful there. So I agree with you. Yeah. Thank you. Thanks.
Thank you very much, Professor, for enlightening us about Drittwirkung. And I'd like to greet and welcome Professor Julio Aguiar, who has joined us. It's a great honor to have you here, Professor. I believe you would like to ask a question to Professor Dr. Martin Borowski. So please, if you may.
Thank you, Lorena. It's great to see you, Martin. It's a long time since I've seen you the last time. But it's great to see you here. Great to see you. Yeah, great to see you all. There are some questions ahead of mine here, but I'm going to use the privilege of being here, of being one of the organizers, and I just want to. Very briefly, Martin, I just want to hear you talking about immigration connected with the Drittwirkung connected with this you just said. I'm not going to imagine queues being being queuing in front of your house, but I just can imagine that kind of queue in front of Germany. I would like to hear you from this issue, and that's all. I'm not going to go further. I'm seeing here there are more questions, and we have to keep it as fast as we can, so many more people can participate. But it's great to see you, Martin. Great to see you, Alexandre, and thank you a lot, Lorena.
Thank you, Professor. So please, you have the floor, Professor Martin.
Well, thank you. Immigration and rights to protection. Well, this is not. This is a kind of has a political background, of course, as we know. The general problem is there some territoriality. So are German constitutional rights, and particularly rights to protection, because I think the Drittwirkungs issue with an eye to the immigration question has most of its thrust in the direction of rights to immigration. Is the question is actually accepting immigrants as into the country with some kind of legal status, a means of protection. I think this is the very point. And this is I think this is nothing that has been very clearly debated, but in some sense it begs the question about the territoriality of omissions. This is the tricky bit of your question, the territoriality of omissions. Now, it is accepted doctrine in constitutional law that the German state is committed to constitutional rights as far as German jurisdiction intends, and this is basically also extraterritorial. So if German soldiers on foreign ground commit some forms of unfortunate, some atrocity or criminal act or whatsoever, and this can be attributed to the German state because they're acting in an official capacity, this would be understood to be a violation actually of Germany's constitutional rights. So German constitutional rights are not actually limited to German soil. So this is the first part of the answer. Now, of course, with omissions, because with omissions, there are so many different ways of actually fulfilling your obligation to protect, at least prima facie. The question is actually how far do these omissions extend? What omission actually is an omission that counts as at least an interference? That would be the language we would constitutionally use, as an interference with a prima facie duty to act. And this, unfortunately, is what I would call a white spot on the landscape of constitutional theory, because basically, to describe just what I would think is a fair assessment of the current doctrine, people are fairly clear that the extent of definitive obligations to act, positive rights, the definitive extent of the constitutional obligation to act is determined by means of balancing. This is necessarily the case structurally because the right to protect person A can be used as a limit of person B's liberty. Now, and in determining whether the liberty is violated, you have to balance the liberty against the positive right. Now, balancing actually is symmetric. If you can balance A against B, you can balance B against A. So, and people just, without discussing it much, just assume and accept that balancing is at stake. Now, the crucial question is, and this is, so to speak, the white spot on the landscape. The question is, how far does the prima facie obligation to protect extend? So far as it extends, you have to balance. At least, well, we don't, again, this is also not perfectly clear, whether you procedurally under obligation to balance explicitly, or whether you are only required to have the result, the correct result, but not to undertake the actual balancing. Okay, so it's procedural versus result question. This is another topic. But the question is, how far does this prima facie duty extend? And this is simply controversial. Now, in the easiest way, but this is a kind of, I wouldn't call it cutting a corner, in some sense it is, would be to say, well, if we don't know where the limit is, there is none. And this is the suggestion that I have in my chapter, so to speak, on the structure of constitutional rights. And then actually it is just as we have the general right to liberty in the German constitution, you have a general right to protection. Now, often definitive rights to protection are rare. Now, often it is perfectly clear that even if you had a kind of far-reaching right to protection, there would never be a definitive right to protection because the counter-arguments are so convincing. And then actually whether this extends beyond that isn't really a practical matter. So this is why people don't discuss this as a matter of protection. Now, the problem, of course, we have here is that where immigration, well, if it comes, okay, let me say at least a couple of things. Immigration is, of course, a very, very broad church, is a very broad concept. You have refugees, people who are in dire need, whose lives are really endangered, and because of the intensity of interference, there is a good point to say, well, here needs some protection to be offered. Now, Germany does that already. I think many states do this already under the traditional international law instruments and some regional instruments. And of course, the next question, and this is a very tricky one, and international law and international politics come into play. Well, if this was Alexander's basic idea, and I tend to follow him at least on the moral side of things, if with capabilities, obligations arise. If you look at the immigration problem from the perspective of one national state, of course, the problem is you have so many holders of the right to protection, but you also have relatively few addressees, because you as a national state, you are not alone. There are other member states who are in more or less wealthy in the sense that they can grant this kind of protection. And this is why we see, at least in the European Union, you are, of course, in Brazil is a different continent, but in the European Union, you see the attempt of addressing this kind of addressee problem when it comes to this aspect of right to protection, to kind of have a common approach and common rules to the immigration problem. Now, unfortunately, to establish a legal framework has proven to be politically very difficult, because there are some notorious member states who shall not be named here, are very much opposed to do anything for reasons we don't have to discuss here. But in principle, I think it is with all these problems and caveats, it's Giulio, a tough question. Thank you. Okay. Yeah, and I think we have questions from the public.
Yeah.
Yes, we do. Thank you very much, Professor. Would you like me to ask all the questions at once or separately?
Well, let me say, just go on asking questions, and at some point I say enough.
Okay.
Depending on the difficulty and so on, and we try to break it down in some portions. Some questions can well be addressed in conjunction. Some others are so complex that maybe start with 2 or 3, I would say.
Okay, so
whatever you think is best. Yeah.
Okay, so we have a participant here called Mr. Santos, and Mr. Santos has some questions. So his first question is, my question concerns the horizontal aspect of basic rights in contracts. There is a lot of debate on that subject in Brazil, and I'd like to know about the state of that debate. So horizontal aspect of basic right in contracts in Germany. And continuing also, Mr. Santos would like to ask, what kind of circumstances would justify this type of action? And if you believe that an intervention by the judiciary or even the executive branch would be acceptable without previous legislation. So he's talking about the omission, the inexistence of legislation by the legislative. And I think he quoted paragraph 60. There might be, under exceptional circumstances, a definite constitutional right of members of the population to have the company's freedom to pursue one business as one wishes, limited. Is that a quote? I would like to ask Mr. Santos, because it's paragraph 60 here. I'd like to know if this quote is from
Lorena, if I may suggest something, you could answer the first 2 questions regarding
yes.
Contracts, how the debate is in Germany, and whether intervention or interference on the right of the parties to so to say, to establish contracts can happen in the name of a constitutional right without a legislative provision. I think you could answer, Martin, these 2 questions, because in my view, the third question, when he talks about, it's not clear. I ask Mr. Santos, who I suppose is
correct.
Giltonio Santos, or?
Please
So I asked him nice to have you here, Mr. Santos. I asked him to rephrase the third question, which seems to be the third
perfect.
question.
Thank you, Professor.
Okay.
So, Professor.
Okay, so this is me trying to give an answer now. Well, I'm not familiar with the Brazilian debate on these aspects of basic rights in contracts. Well, I talked about well, the contract is a legal act that is established by two parties making use of legal power that is attributed to them. There's, of course, the first aspect is you have to have the power to enter into contracts. This has never been a question because no one in private law has ever tried to abolish contracts, obviously. But basically to enter into contracts with whom you want, about what you want, is a prima facie constitutional right. Now, this is obviously limited. This is obviously limited because you are not supposed, for example, to sell some member of your family you don't really like as a slave to someone. So there are limits about what contracts can do for the sake of protection of other people. So there are limits to what contractual freedom can be used for, but that you can enter into contracts and thereby you give rise to legal obligations that have not existed before is actually something to what the Constitution you definitely entitles. Now, as I said, there are limits of what can be done in contracts. And of course, the example of selling someone into slavery is a bit crass, so to speak, as an example. And is not something that happens in legal cases, at least not nowadays, fortunately. But there were contracts for which constitutional limits by means of indirect Drittwirkung were declared. We had the example, Alexandra mentioned this, labor law. Now, in labor law, you have an employment contract. And the conditions of employment and payment are, of course, fixed in the contract. Now, this is not supposed to be, blunt, so to speak, some kind of modern form of slavery. The conditions of employment, that you're not exposed to poisonous substances, that you are entitled to some protection if you do dangerous work, for example. These are definitely constitutional requirements that can be set and enforced by means of indirect Drittwirkung in constitutional law. There was another case which was actually sparked some, what should I say, was seen as a kind of sensation in private law 2 or 3 decades ago. Alexander, was heißt Bürgschaft?
Bürgschaft, Cidadania, citizenship.
Nee, Bürgschaft it means. I'm talking about, sometimes if someone is self-employed, has a small company, and now the bank lends money to the company. Now the owner of the company now has a wife, and the wife has no money. She basically has a husband. She has no money. But the bank asks, okay, we have this debt of 5 million euros. Now, if you can't pay back these 5 million euros, we come after you, the company and the husband. And they also require the wife, who has no money and has no, let's say, talent or whatever profession to earn a serious amount of money. But they ask, okay, well, she has to underwrite too. so that whenever she has some money for whatever reason, wins the lottery or so, we go and get the money from her. And this is German, it's Bürgschaft. It's kind of, you basically guarantee to pay another person's debt. Mm-hmm. And now the German Federal Constitutional Court said at some point there was a practice of German banks to require also family members who had no money to also underwrite these loans. Well, the problem in practice, of course, was that in some cases, the house and the car, when the bank came, was owned not by the husband, but was owned by the wife. And so he transferred the funds so that they couldn't go after her, and so they kind of tried to avoid this. But of course, the problem is that if the company goes bust, this poor wife has no chance of actually financially recovering from that ever. And there's no legitimate interest of the bank usually to have, in such situations, these people actually underwriting all these obligations to pay this money back. And the Constitutional Court basically said, well, this is a question of right to protection. These financially powerful banks are simply not entitled to ask for their own very little theoretical benefit to cause these problems for family members in these set of circumstances to be responsible for these enormous amounts of monies in which they had no themselves only the very direct benefit of being a family member, but no direct involvement, so to speak, in the normal financial operations of the company. And so they said if they had underwritten these debts also, this is null and void. So in terms of the autonomy of the individual, which is the kind of liberal approach to private law, well, you can enter into a contract and you can promise to pay someone 5 million euros back even if you have no money. This is technically, in the orthodox doctrine of German private law, this is possible. But of course, they had to realize that also private law is not an autonomous part of the legal system, but is also under the Constitution, and that the Constitution can set limits to what, in their view, would be actually a proper contract into which a person has entered into. And this is not only these cases, but think of this as a pattern that the content of contracts can be constitutionally limited. And also in terms of, if you talk about labor law, gender discrimination, if you are asked by your employer as a female applicant for a position, actually, are you pregnant? Do you intend to have a family or something like that? You can basically say what you want, because if you were required to answer this properly, this would be some form of discrimination. And so, yes, the contracts are acts, legal acts in the horizontal relationship, and this is vertical rights to protection can limit what can be done between citizens, even in contracts. And this was a long answer, I have to say, to the first question. The answer to the second question will be quicker. Well, you asked, what shall we do if we have this Hessian case? If there is no act of parliament that can be interpreted in conformity with the Constitution? Well, the basic answer is, you would say, well, technically, I said the answer is a right to legislation. Now, what happens? The legislation, the parliament does nothing. So the Constitutional Court says, there's a complaint. The Constitutional Court says, well, parliament, you're supposed to do something. And then the Constitutional Court gives an outline what this something is. So what is supposed to be there? And the court says, well, it has to be a statute that looks like this, blah, blah, blah. And then there comes a kind of description. And then they say this needs to be done at the latest in 3 years' time. Okay, well, our parliaments, we know what parliaments are. Parliaments are doing political work and have all sorts of agendas, all sorts of crises evolve, come and go. And maybe after 3 years' time, nothing has happened. What can be finally done? Well, the problem is, because of separation of powers, it would be very demanding for a constitutional court to say at the end of the day, well, we asked you 3 times to do this. We gave you enough time. We gave you guidelines what to do. Now you have done nothing. Now, finally, in the 3rd or 4th round, they technically could say, well, all public authority has to assume that there is a parliamentary statute that looks like that until they have done this properly. Technically, in Germany, this would be, as an extreme ultima ratio, would be possible because all public authority is committed to judgments of the Constitutional Court, which is an explicit provision in the Constitutional Court Act. This may come too late. This may come too late if there is a kind of urgency. And I'm inclined to think, this is not a broad debate, but I'm inclined to think that the requirement that if another party's liberty must be interfered with, if there is a definitive and clear right to protection, that this formal requirement that there needs to be an act of parliament, if because of the extreme circumstances of the case at hand, it is clear that there is a definitive constitutional right to protection, and there is no time for all sorts of going through the stages of legislation and waiting years and years and years. At some point, one might be able to say, actually, this formal requirement that there needs prior authorization by parliamentary statute is actually outweighed by the dramatic danger for many people in substantive terms. However, this is a kind of, it's easily said if I say this, but one has to accept that there is a kind of, this is not a scientific term, but it's a kind of taboo to go against the requirement of prior approval of interferences with liberty by parliamentary statutes, because it might prove to be a slippery slope. We would have this kind of meta debate whether you're supposed to enter this dangerous idea of weighing away the requirement of prior authorization by law. But there may be clear cases. Yeah, I would not let people die because there is no act of parliament, as a punchline. Okay, well, I don't know if this was shorter, but at least it's I'm over with the question, not generally.
Thank you. Thank you very much, Professor. I believe we have been transplanting, if I may comment your answer, we've been transplanting some of the theories from Germany to Brazil constitutional review, and we have been applying the non-concrete theory as well for our abstract and concentrated review. But we have already applied the intermediate concrete thesis here in Brazil as well. So giving a notification to the legislative and giving a time, and after the deadline, then the Supreme Court would, of course, establish the parameters for the exercise of the right, of the fundamental right. So we have another question from Miss Araújo, and she is a PhD student, and she is studying about the right to hope against the right to health of seriously ill patients. And she would like to ask, do moral rights make sense only between private parties, or between state and private parties as well? And if I may, Professor, I'd like just to ask another question by myself, just about emissions of the state concerning Drittwirkung, because constitutional rights, they are interpreted, and they are interpreted by the Bundesverfassungsgericht. So I'd like to know why is the legislative in Germany bound by this constitutional interpretation? Wouldn't that mean a facilitation of the legislative? So that's my question. Thank you very much. Are you listening to me, Professor? Am I audible?
I just want to make a short remark. Frau Araújo's question. Frau Araújo is not a PhD student anymore. She has already defended her PhD thesis, which was about the right to hope. Professor Borowski does not know her personally, but we have had contact. Personally, yes. Yeah, I'm listening, yeah. Okay, so, but anyway, thank you very much, Frau Araújo, for being here with us. And hello.
Thank you.
Okay.
Thank you. I'm sorry. I'm sorry. Thank you.
Okay. Yeah, thank you. The right to hope and health of seriously ill people. I'm afraid I'm not aware of the precise context, which probably is there. So can someone fill me in on the context?
From her thesis.
Yeah.
Yeah.
Alejandro fills me in.
Yeah. Frau Araújo's idea, can you hear me? Yeah. Okay. So Frau Araújo's PhD thesis was about mainly the problem that we have in Brazil, that usually people with very serious diseases go to the judiciary power and ask for some measures. Especially, they ask for treatment or medication that usually the system does not pay. And they claim that this is necessary in order they survive. But it's not foreseen, for instance, either by legislation or by the public policy itself, as it is created by the executive power. And then Frau Araújo's thesis was mainly that these people go to court because they base their claims on a right to hope, which is, in her view, is a moral right, but not a legal right. So it seems to me her question has to do with the idea that whether this moral right is only a moral right that cannot be, if I understood correctly, the question, I mean, which is a moral right that cannot be transformed into a legal right. I think that's the point.
Okay, well, yeah, thank you. I think the general thrust of my take on Drittwirkung, and of course, Drittwirkung is a fundamental property of constitutional rights in general, so it's basically a fundamental take on constitutional rights and their nature, is that morality and law are very much intertwined. And if you have relatively broad terms in the Constitution, general terms, then I would tend to think that morality, so to speak, generally requires that to be taken into consideration in interpreting the legal arguments. So, of course, you can argue, you can say, well, we have here some kind of a set of moral rights, but the Constituent Assembly that created the Constitution accepted only 8 out of these 10 moral rights to be constitutional rights. So they explicitly reject some moral rights, and only 8 of the moral rights are accepted. Then you could say, well, okay, not all 10 moral rights were transformed, only 8. but that would require a relatively specific decision against the transformation of something that is on the other side accepted to be a moral right. This is a very weird way to think about things. Usually, a constituent assembly asks themselves, what does morality require? And then makes an effort to transform what morality requires from us in our dealing with other human beings, to transform this into constitutional provisions here. So that something that is morally required plays no legal role is from the outset is a bit strange as an idea. Of course, what is a more realistic way of thinking at it is, you may remember that I emphasized when it came to the transformation of morality into law, I said, well, morality, what is well known, is often contested. And if it comes to these cases in which, as far as I'm aware of the issue, I'm remotely aware only, but as far as I'm aware of the issue, these are treatments that one would oneself probably pay for if only oneself had the money to pay for. But many people, unfortunately, do not. Now, the problem is, of course, if you are asking for the use of public money, the use of public money, of course, has a distribution issue. Because with a certain amount of money, you can not only pay this treatment for this person, you can pay this treatment for another person in a similar situation, or an even more desperate situation. You can use the money to do something completely different with it, with more or less legitimate use to the public. Now, because we have this distribution issue here at stake, the problem of the cognition of what is morally required, the problem to understand what morality under these individual circumstances require from us, it will be contested. Now, this is why we need authority, and authority in this case, in this sense, is, I tend to think, even remotely knowing the issue only, I tend to think is some kind of centralized approach, which at least does some planning. Why? Because all these competing uses for public money, all these competing uses must be known. Now, if in an individual court case, someone who is definitely desperate, in a desperate situation, says, well, I need this money for this treatment, and this is probably quite some money, it's not a small amount, we may not know, the court cannot know how many other people are in comparable or even more difficult situations without access to the law, without access to lawyers. There comes a social issue, comes into play. How well are you able to phrase your arguments before a court? And this is easier if you at least have some money and are educated. And so there needs to be some planning to make sure that at least in the understanding of a legislator who has democratic legitimacy, there is a kind of general plan in the sense of a parliamentary statute that lists some priorities based on some planning, how many people will be in what kind of situations before the courts, does some planning and organizes the situation to some extent. And to extricate by means of interpretation justice in an individual case from just these very general phrases of the Constitution and a kind of desperate set of circumstances in a very concrete case, but money competing for hundreds and thousands and tens of thousands and hundreds of thousands of cases, is nearly an impossible task. So the likelihood that if you accept many constitutional cases as this, in the sense of the right to hope, that you come up with a with a distribution of public funds that is less than optimal. And optimal is those who need it most get it first. This probably is the distribution issue that actually decides the problem. And then, in some sense, you may say, well, basically there is a prima facie constitutional right, but it has to be concretized. There has to be some concretization by means of the democratically elected parliament, and then courts decide in actually commitment to this parliamentary statute. And only if this proves to be grossly unjust, so to speak, indefendable in some sense, then the Constitutional Court can step in and can say, well, your parliamentary distribution of money is actually unconstitutional. But before that, because these matters are so contested, I find it difficult to advocate on behalf of a very generous reading. As much as your heart, if you hear the circumstances of it, as much as your heart wants to help, but there is a greater scheme of things, and there are other people in dire need, and the judge only looks at this case before her or him, and the oversight of the general situation gets lost. I think this is the main problem here. Thank you very much for the second question, whether morality only plays a role between private parties. Well, the state actually is the general association of all private parties. So in some sense, the state is something different from private parties, but on the other hand, the state basically is us all in some sense. And of course, the state, I said this, the morality does not presuppose the state as an actor. However, if the state is there, and if capability brings obligations with it, then I would argue that actually the state is a very important moral actor. At the end of the day, the state, if this transformation metaphor actually has something to it, then of course it is the state which legally fulfills the legal obligations and thereby enforces, of course, morality. So thank you for this clarification, or at least for the chance to allow me to clarify it. Of course, the state is a very important moral actor. It is just for making clear the specifics of morality that I said that you don't need it for morality. But of course, it's there. It has always been there as a historic issue, and it would just be a thought experiment of the state of nature. But yes, the state is actually a very important moral actor. And then Lorena, you asked whether the interpretation of constitutional rights, what the point is of legislators being bound by a decision of the Constitutional Court. Well, in one part, I think of at least my reconstruction, or the reconstruction that I outlined. It's not that I own it in a very certain way, because it belongs to a tradition in which I'm rooted, only in this sense. If you think about the rights to legislation. Now, if you think of a system in which the legislator is not bound by decisions of the Constitutional Court, and the Constitutional Court says, well, you have to enact a parliamentary statute for the sake of protection of people XYZ, then the legislator could just say, no, we see it differently. So they have to be committed. Interestingly, the extent of the commitment is contested. the leading commentary, academic writing, says that it's only actually the decision in and of itself, the tenor, basically between the parties, so to speak, what is explicitly ordered is the commitment, while the Constitutional Court itself says, well, our leading arguments in the justification of a decision, ratio decidendi, they are also binding for everyone. But it's only them, and I don't think that because the others are the addressees and they say no, this is basically it's the narrower version that counts. But in that sense, it becomes systematically important that even a directly democratically legitimated parliament is bound by the Constitution. If the Constitutional Court, in interpreting the Constitution, says there has to be such a statute, they are committed to it. Of course, everyone tries to avoid the direct clash, and this is all kind of diplomatic dancing going on in these cases. But ultima ratio, it would be the case. Yeah.
Thank you very much, Professor, for your answer. I was thinking about that, considering Brazil's situation. And we have already had an admission by our Supreme Court about his wording. It's not final, because the legislative would have legitimacy, democratic legitimacy, to act in the future, subsequently, in disaccordance with their ruling. But this is very, very important. Thank you very much. We have a final question from Mr. Barreto, and he's asking, the horizontal efficacy of fundamental rights is able to limit the discretion of judicial organs, and if so, in which ways?
Lüt, Blick für. The phrase contra bonus mores, gegen die guten Sitten in German, is a very vague term. Now, and of course, classic private law scholars had a kind of, we could say, kind of morality, what a decent person morality does and what he or she does not. And this was the basis on which they determined which kind of actions would go beyond contra bonus mores. Now, what did Erich Lüth do? He called to a boycott because he was politically opposed to this Nazi film director. And it was a political act in some sense. And traditional German private law would say, well, you are not supposed to politicize these kind of economic issues, and said it, following orthodox German private law, this might have reasonably been some kind of action contra bonus mores. Now, what happened now with the radiation effect, Ausstrahlungswirkung? The discretion of the judicial body is limited because, owing to freedom of speech from Erich Lüth, he politicized the matter, but freedom of speech says he is perfectly legitimate. He has perfect legitimate interest in politicizing any matter he thinks is worth politicizing. And at the end of the day, this person was outrageous anyway. So what technically happens? It happens that there are the canons of interpretation which the private law court uses in interpreting the phrase contra bonus mores. The wording, legislative intent, the system, this damages provision is part of a greater system of German private law. and all sorts of arguments in legal methodology. Now, what is added here to the methodological limits of judicial bodies is the interpretation in conformity with the Constitution, which is based simply on the insight that the Constitution is formally superior to sub-constitutional law, the Act of Parliament. And if you take the legal nature as immediately effective and applicable law, the Constitution as immediately effective and applicable law seriously, and the superior status seriously, then interpretation and conformity brutally cuts out all interpretations which would be, from the point of view of legal methodology, with an eye to simple statutory law, would be applicable, and cuts out all that are violating the Constitution. What is left is what is in conformity with the Constitution, and that was the decision in Lüth. I think this is technically the way in which Drittwirkung, horizontal application, a horizontal effect, actually technically influences what judicial bodies can do in terms of legal interpretation. And I hope this answers the question appropriately.
Sure. Thank you very much, Professor. We had the last question, unfortunately, due to some further commitments from Professor Dr. Martin Borowski. So I'd like to give the floor to Professor Dr. Alexandre Travessoni. Professor, your microphone, please. Professor, you are on mute.
Liga o microfone, Alexandre. Liga o microfone.
Professor.
Ô, Alexandre, liga o microfone aí, filho.
Professor.
Microfone, Alexandre. Olha o microfone, você não ligou.
I apologize.
I could hear that he's in my room, so apologies. I didn't realize.
Yeah, no, I just wanted to stress that Martin would be ready to stay more, but we just think that we are already more than 2 hours here, so it might be. I think we had already had a good discussion. I want to thank again all the members of the organization, Lorena, who moderated this virtual meeting, Júlio Aguiar de Oliveira, my good friend and colleague who is here, Alexandre Barreto, who also helped very much with the organization, and all the people behind the scenes, Ícaro and Gabriela, the undergraduate program in law, and especially my good friend Martin for this wonderful lecture and wonderful discussion. Would you like to say a final word? Or
well, just very briefly, thank you for having me. It was actually exciting. Thank you for having me. Look forward to the whole thing. It was exciting to have a discussion with you, and as often, but not always, but in this case, definitely, I had some interesting thoughts, and it definitely helped me to develop things further. Well, thank you. And I think we have stressed the patience of our audience enough. There are some obligations at some point, but we have done enough. And if this strikes you as a good idea, of course, we can always think about doing something else on a different topic in the future. I would be perfectly happy. Thank you.
Thank you. Thank you very much, Professor. I'd like just to before finishing this utmost important event, I'd like to thank Professor Alexandre Travessoni. Thank you very much, Professor. Thank Professor Júlio Aguiar. Thank you very much for organizing this event, this excellent event. Professor, thank you very much, Professor Martin Borowski, for being with us today and having the opportunity to take part in such great discussions. And I'd like to thank, of course, all of those who made this event possible, Ícaro and Barbara as well, Alexander Marques, and the audience as well, and the postgrad program from Catholic University of Minas Gerais, in the name on behalf of Professor Marciano Godoy, the head of the program, and also the Foundation of Research from Minas Gerais, which assists and aids us in researching here in our state. So thank you very much to all. Thank you for your presence, and we hope we have you here again remotely with us in Brazil soon. Thank you very much. Have a great day. Bye-bye.